Today we're going to talk about objecting to the appointment of a personal representative and removal of a personal representative. My name is Gregory Singleton. I'm an estate planning and probate attorney located in Minneapolis, Minnesota. I work for Signature Law, which is a estate planning and probate law firm that serves the Twin Cities and Greater Minnesota alike. Just a reminder, if you like today's video, please feel free to smash that like and subscribe button. It truly helps support the channel. Two pieces of housekeeping before we start. This video is only going to be discussing Minnesota law. If you are in another jurisdiction and you have a question, you need to talk to an attorney in that jurisdiction that is licensed in that state, and they can help you out. Though a lot of the theories that we talk about will translate to other states as well and give you an idea of what to talk about. Secondly, this video is not legal advice. It is for educational purposes only. I say that because I don't want to establish an attorney-client relationship with all the viewers on YouTube. That would be very complicated. So, objecting to appointment of personal representative and removal of a personal representative. Last video, we talked about the situation where multiple people were qualified to be personal representative. We said there were two ways you can deal with this. One, let's say there's three people. Two of the people can renounce their right to be personal representative, leaving the third person who wants to be personal representative to be personal representative. Second, let's say there's two people. They could be co-personal representatives with equal right to administer the estate. But what about the situation where there are two people qualified, equally qualified to be personal representative? They each want to be personal representative and they don't want the other to be personal representative. What do we do in that situation? Well, the first thing that happens is there is a race to the courthouse. When you file a petition or application to be personal representative, you have to make a statement under oath that no other probate has been filed. So whoever files first is the probate that we're going to follow. After that, whoever filed the probate must give notice to all of the interested parties. Coincidentally, that will include anyone that has a right to be personal representative. It just works out that way. After the notice has been given, anyone that is an interested party has a right to object to the appointment of personal representative in the petition or application. If there is an objection, and you're in an informal probate, it'll automatically be kicked up to formal probate because there is going to be a hearing in front of a judge. And the court is going to appoint, after hearing everyone's position, they'll appoint who's going to be personal representative. They have a lot of discretion when making this decision. Now, they have a little bit of guidance here. First, they should appoint any person who is a devisee or heir of the estate that is receiving more than 50% of the assets in the estate, and that everyone can agree to. So if there's three people and two people are vying to be personal representatives and they just don't want the other person, but there's another guy that's earning 60% of the estate that everyone's fine with being the personal representative, that person is going to be appointed personal representative, as long as they want to do it. If nobody can agree or that situation just doesn't exist, then the court is going to appoint any person they find suitable. That is a huge amount of discretion. So if you go into one of these hearings, you don't want to look bad. Don't look mean. Don't look crazy. Look respectable and do what you can. Let's say you missed your opportunity to object and your rival, your arch enemy, got appointed personal representative. How do you remove them? Well, first of all, any interested party can remove another person as personal representative. Interested party is going to be someone who is a devisee or heir of the estate who is getting something from the estate. What they have to do is file a petition for removal of personal representative for cause at any time after appointment of the personal representative. So what's cause? That's the big question. Well, it's broad. It's very broad of what cause is. There are 6 enumerated bases for removing someone from being a personal representative. And the court's going to look to each of these to see if there is cause. Now, the first one is when removal is in the best interests of the estate. How broad can you be? This basically gives the court as much discretion as they need, as much leeway as they need to make sure things are done right. Beyond that, if a personal representative intentionally misrepresented material facts in the proceedings leading up to appointment as personal representative, they can automatically be kicked. This would be, for example, I've seen this before, where you have an interested person, they put in their application to be personal representative. As part of that, they have to say under oath that they have served notice on all interested parties. But what if they didn't serve notice to someone because they thought that other person would object to them being appointed personal representative? They can be kicked out of that. They can be kicked out of being personal representative for that reason. The other four bases for removal of a personal representative are if the personal representative disregards an order of the court, they can be removed. If they are incapable of discharging the duties of office, they can be removed. If they mismanage the estate, they can be removed. And if they fail to perform any duty pertaining to the office of personal representative, they can be kicked out. So that is the contested reasons for removal of a personal representative. But there are ways of amicably being removed as a personal representative. For instance, a person can resign. Let's say they sign up to be personal representative and it just turns out to be way more complicated than they thought. They just can't handle it. In that case, they file a written statement of resignation with the registrar. They have to give 15 days notice to all interested parties. And then here's the kicker. If nobody else wants the job, the resignation is ineffective. The resignation is only effective if upon appointment, or is effective upon the appointment and qualification of a successor personal representative and the delivery of all assets to the successor personal representative. So once you sign up to be personal representative, you may be stuck with it. The second way to amicably be removed from being a personal representative is very simply to close the probate. If you close the probate informally, meaning not in front of a judge, then you have 1 year after filing the closing statement, during which time you're on the hook and liable if you made any mistake. And after 1 year after filing the closing statement, you are discharged informally as personal representative. There's no order of the court, it just happens. If you close a probate formally, the court will actually issue an order removing you or discharging you as personal representative. Now, when I say formal and informal closing, that's slightly different than formal and informal probate. With the same concept, formal is going to be in front of a judge and informal is going to be in front of the registrar. You can close a formal probate informally and formally, but we'll talk about that in another video. So that's it. That is objecting to and removal of a personal representative. I hope you liked today's video. If you did like today's video, please feel free to smash that like and subscribe button. It truly helps support the channel. If you're interested in what we're talking about, we're in the middle of a probate series right now. There's probably going to be another 7, 8, or 10 videos on various topics on probate, after which time we'll switch back to just talking about estate planning and probate and some other things. But we release a new video every other Wednesday, so you can look forward to that. If you have any questions, please feel free to put them in the comments below or just send me an email. Happy to get back to you. Other than that, this is Gregory Singleton from Signature Law.